Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What's Happening in New Zealand, Israel, and Norway? Catching up with international enforcers at the 2024 Antitrust Law Section Spring Meeting. In April 2024, the Our Curious Amalgam team went to the Antitrust Law Section's annual spring meeting in Washington, D.C., where we sat down with an assortment of international competition law enforcers to discuss their agency's enforcement priorities and other issues, while also getting to know them a little bit better as people. In this episode, we'll hear from representatives of the New Zealand Commerce Commission, the Israeli Competition Authority, and the Norwegian Competition Authority. The first segment of this episode features my conversation with Andrew Riseley, head of the Legal Services Branch of the New Zealand Commerce Commission. Before joining the Commission in 2017, Andrew's long career in competition law and economic regulation spanned across multiple jurisdictions, including Singapore, the UK, and Australia. He has a Master of Science degree in regulation from the London School of Economics, as well as degrees in law and economics from Monash University in Melbourne, Australia. And now, without further ado, let's find out what's happening in New Zealand. With me is General Counsel and General Manager of Legal Services for the New Zealand Commerce Commission, Andrew Riseley. Welcome to Our Curious Amalgam, Andrew.
Tina Alicia. Thank you very much for having me.
All right. And what did you just say?
So, Tina is a formal greeting in Te Reo Māori, the indigenous language of New Zealand.
Oh, that's very interesting. That's great. Well, we'd like to ask you today to tell us a little bit of your agency's major achievements and initiatives over the last year.
So, the Commission is very much a multifunction regulator. So we almost cover the field when it comes to not just competition and consumer protection, but also to economic regulation. And so this is probably one of the busiest years in the Commission's history. In terms of individual items, we've just published a draft report in our market study into personal banking services. Obviously a market that's of great interest to consumers, of real importance to the economy, and that's out for consultation at the moment. So we're looking forward to stakeholders providing us with insights into our provisional analysis and recommendations. Just before Christmas, we filed our first criminal charges with respect to a criminal cartel prosecution. The matter's currently before the courts, so there's not much I can say, but cartel behaviour was criminalised in New Zealand in 2021, and so the maximum penalty for criminal cartel conduct is 7 years imprisonment for individuals. And given that Parliament indicated by changing the law that it regards cartel conduct as a serious matter, the Commission has prioritised trying to find an appropriate case to bring this first criminal prosecution. And so, the charges were filed in the Auckland District Court just before Christmas, and we're expecting during the course of the year for that case to play out.
Oh, that is an historic development.
Yeah, and it was well covered in the media, the fact that we'd filed the charges, and I think it helps to give prominence not just to the Commission's work, but also to the fact that cartel conduct is serious, and the businesses need to be aware that they shouldn't engage in it.
So it sounds like from what you've said that criminal prosecution of cartel conduct will be a major priority of the Commission going forward. Mm-hmm. What are some of the other enforcement priorities?
So on our consumer protection side, we've been looking at pricing cases, greenwashing cases. We've got a number of cases before the courts in relation to those matters, things like country of origin. We're conscious that we have a new regulatory regime for grocery retailing, which the Parliament gave to us in 2023 following an earlier market study into groceries. And so one of the priorities for us is making sure that new regime works in terms of the regulation of the relationships between grocery suppliers and the grocery retailers. We have our kind of 5-yearly reset of the revenue requirements for electricity distribution businesses and electricity transmission businesses and our fibre networks. So yeah, quite a lot on in terms of things that are happening and things to come.
How large is the commission? How large is the staff?
So we're about 450 people. So a relatively big agency in terms of, particularly in terms of New Zealand, but we cover the field. So when you're a jurisdiction of 5 million people, there are economies of scale in having everyone sitting together. I should also say, in terms of priorities, we have a Rotaki Māori, a Māori strategy that got developed last year and developed and published last year, and it indicates how the Commission is going to think about how to make sure that the work that we do is of relevance and importance to Māori communities in New Zealand.
Very good. And looking ahead, if you can you give us a hint as to what sort of the future might bring for the Commission, or the trends or priorities on the horizon?
So I know our chair is very keen for us to maintain our enforcement stance, but to be seen by stakeholders and by the general community as a vigorous enforcer of our laws. It's fair to say on the competition side that much of our enforcement over the last 10 years has focused on cartels. Obviously, cartels, for the reasons we just discussed, are problematic, but where we are trying to extend our reach a bit more is into unilateral conduct cases and effects-based litigation. Our unilateral conduct provision got amended in 2023, so it now mirrors the unilateral conduct provision in Australia. And the Commission had been advocating fairly publicly for the unilateral conduct provision to be overhauled. So I guess we think it's now incumbent upon us to bring those cases and to start to put some of those matters in front of the courts so that they can start to provide us with law on that new provision.
Well, it sounds like you and your colleagues are going to be extremely busy. If you have any free time at all, can you tell us something interesting about yourself or interesting hobbies that you have that are outside of your professional life? Sure.
So the first thing I'll do is just quickly do a shout out to one of my colleagues who is a massive fan of the podcast. She's a legal advisor in my competition legal team. So Tanuvi Garamella, who does not miss an episode of Our Curious Amalgam. So hello Tanuvi.
Thank you, Tanuvi.
She was extremely excited about the fact that I was going to appear on the podcast. So kia ora, Tanuvi. Well, one of the things that not a lot of people know about me is that I was a Rotary Youth Exchange student at high school. I grew up in Australia and headed to Sweden for a year. In high school, it was about as far away from Australia as you could come. And having done that quite some years ago, one of the things that I do when I'm commuting on the bus is use the language learning app Duolingo to try and keep my Swedish up, but also to learn new languages. I am a fan of genealogy and discovered recently that I have some ancestors who were Portuguese Jews who were thrown out of Portugal in the Spanish Inquisition and made their way to England and eventually to Australia. And so I'm endeavouring to learn Portuguese as well.
Well, I'm a Duolingo user too.
Very good, Lisa.
Japanese and Spanish and Korean.
Fantastic. Yeah, fantastic.
But not all at the same time.
No. You do have to focus a little bit, but it's great fun.
All right. Well, thank you so much for coming in and talking to us and bringing us up to speed on what's happening in New Zealand.
Thank you so much for having us.
In the next part of this episode, I'm speaking with Joshua Sherman, who has been serving as the Chief Economist of the Israel Competition Authority since early 2023. A former senior consultant with Charles River Associates, Josh continues to teach courses in antitrust economics and law and economics at Northwestern University. His own academic work focuses on competition and pricing behavior. Before we start, as a companion to our interview with Josh Sherman, listeners can check out Our Curious Amalgam episode number 175, which we published in July 2022, entitled, Who is Michal Halperin? Meet the former Director General of the Israeli Competition Authority. I'm here today at the 2024 spring meeting with Dr. Joshua Sherman, who is the Chief Economist of the Israeli Competition Authority. Welcome to Our Curious Amalgam.
Thanks so much. It's great to be here.
Let's just dive right in. The questions that we were asking all of the international enforcers this year. To start off with, what are some of the major accomplishments or initiatives of the authority?
So one accomplishment over the last year related to a proposed merger between a large insurance company and a large credit card company in Israel. So the insurance company is called Harel, and they're the leading insurance provider for private health insurance. And much of the private health insurance is sold via brokers in Israel. And our primary concern there was that the unique and rich transactional data that you get from a credit card could be used to build a model that would allow the new emerged entity to price discriminate among customers for private health insurance. And for brokers, this would be a clear differentiator for them. And we were concerned about a scenario where that might lead to partial or complete foreclosure of Harel's competitors for private health insurance, and ultimately the parties, Harel and Isracard was the credit card company. Ultimately, they abandoned the merger. A second one, I would say, related to research. It's really kind of an ongoing initiative, which is our research, for us at least, on an unprecedented scale into the food sector in Israel. So several months ago, we asked for highly detailed data from at the level of the barcode from 16 major suppliers and importers, as well as 5 major supermarkets in Israel for a 4.5-year period. And the level of food prices in Israel has been a problem for many years, and we've embarked to conduct a careful empirical analysis in order to identify and quantify the sources of the problem, and also perhaps to identify whether there are particular governmental regulations that substantially influences prices paid by consumers. And I would say a third accomplishment, not only over the last year, but really over the last several years, pertains to our criminal enforcement of cartel and big rigging offenses. So in Israel, our sanctions include both a maximum term of imprisonment of 5 years, as well as monetary fines. And in recent years, we've brought, on average, somewhere between 3 to 4 cases. As evidence of our success, just a few months ago, there was an article in the Journal of Antitrust Enforcement that looked at why countries with criminal antitrust sanctions fail to incarcerate price fixers. And the article pointed out that Israel was a notable exception to the rule, noting that our rate for obtaining prison sentences is impressive, and that given the size of our population, the rate of cases we bring each year on average is very significant compared to other jurisdictions. So I guess that would be the third thing I would highlight.
That's very interesting. Now, obviously, the food sector seems to be an enforcement priority and probably will be for some time, is what it sounds like. What are some of the other enforcement priorities of the agency?
So in terms of sectors, in addition to the food sector, I would say the financial services industry, to include credit card, insurance, banking sector. Banking sector is both highly concentrated and characterized by very high barriers to entry. And in terms of enforcement-related kind of topics, I'd say one area of focus for us is looking at behavior of merging parties prior to approving or opposing a merger, such as agreements to kill or chill competition prior to a merger decision, as well as the exchange of certain information between the parties during the merger review process. So that's one area that we've been focused on. Another area would be related to firms' leveraging of big data and the analysis of vertical and conglomerate mergers. And a third that I would point out would be the entire area of partial ownership. So the issues surrounding it, including cross ownership, common ownership, concerns regarding passive investments as well as interlocking directorates, both horizontal and vertical concerns, and also unilateral and coordinated effects.
Now, sort of looking ahead, this is what's happening now, and looking ahead, either to the near or slightly farther out into the future, what do you think will be some of the trends or perhaps challenges that the agency is going to face?
Maybe I'll start with challenges to get that out of the way. I think a lot of competition authorities would say that they would like to have more resources, and so we would join in that statement. We have approximately 100 professionals. We would always be happy if we had more. The second challenge, I think, is conveying to the public the importance of engaging in professional economic analysis based on sound economic theory and careful empirics, when there might be a popular attitude for or against a particular firm or a particular industry. And sometimes it can be a challenge to properly convey the scope of our authority and the way in which we can make an impact as a competition authority. So making people understand that, the law empowers us to bring enforcement actions, to oppose mergers that we deem to be anti-competitive. And these are by definition legal processes that take time. And so it's important that you have experienced professionals in law and economics on our side, because the other side is going to also bring experienced lawyers and economists. And, the real test of deterrence plays out on that playing field. So I'd say that's another challenge. In terms of trends, I think AI is without a doubt a trend that is going to become increasingly important from a variety of perspectives. I foresee an increasing amount of concern related to AI in analyzing mergers, concerns associated with mergers, AI enabling coordinated conduct, in terms of enabling exclusionary conduct such as predatory pricing. I also think that AI, and I've spoken about this with some of the other enforcement agencies, to be increasingly used as a tool to both identify anti-competitive conduct, as well as a tool to be implemented to analyze materials that parties send to us in the process of merger review to better enable us to efficiently understand what we receive.
And are you using some of that technology now?
We are right now investing in it, discussing how we're going to implement that. So we are actively researching it, and my sincere hope is that in the very near future, this will be something that we're able to adopt as well.
Yeah. How big a team of economists do you have?
We have about 30 economists and about a little over 40 attorneys, as well as investigators.
So perhaps the artificial intelligence technology can help you do more with less, as they say.
Yes. I mean, as an economist, I could say that efficiency is important, and that would be wonderful.
Turning to sort of the end segment of our talk, what we want to do is find out a little bit more about enforcers as people. And I'd like to ask you to tell us something interesting about yourself that's completely outside of your professional life.
So completely outside of my professional life, every day I love making up new stories to tell my children that are completely not just fictitious, but totally ridiculous. And the test of whether it's a good story for me is whether I've gotten them to laugh a few times. If I haven't, then I've clearly failed.
And how old are your kids?
My kids are 11. My son is 11 and my daughter is 9.
Oh, all right. So that's a pretty sophisticated age. These stories have to be...
I got to up my game more every single year.
Absolutely. Well, thank you so much. It's been great to have you.
It's been great to be here. Thanks for having me.
Hello, I'm your host, Jaclyn Phillips. As our listeners know, Our Curious Amalgam focuses on worldwide issues concerning antitrust, consumer protection, and data privacy. Today, I have the unique opportunity to sit down with Tina Søreide, the Director General of the Norwegian Competition Authority, to chat about what our listeners need to know about competition policy in Norway. Tina Søreide first joined the Competition Authority in February 2022. Prior to being appointed to that position, she's a professor at the Department of Accounting, Auditing, and Law at the Norwegian School of Economics and has unique experience in the intersection between law and economics. Tina has a PhD in economics and in her academic work is focused on corruption. She's also a member of the Competition Committee Bureau at the Organization for Economic Cooperation and Development, the OECD. Thank you so much for joining us today.
Well, thank you for having me.
To orient our listeners, can you just give us a quick overview of the Norwegian Competition Authority?
The Norwegian Competition Authority is located in Bergen, outside of Oslo. That is actually to keep it independent and away from the capital city. We are around 100 people. We are a pure competition authority. So we do antitrust cases, enforcement cases, and merger cases. We do not have consumer protection and public procurement. And we are part of the ECN network, European Competition Network, even if Norway is not a EU member.
So as you sit here today, what can you tell our listeners about your organization's top enforcement priorities?
With respect to enforcement in general, I think, let me do the boring part first, because I think it is extremely important to work on the basic competence and in enforcement actions, because that requires constant effort. Because in competition authorities, and I think that is common for several of us, we have a turnover because it's very attractive to go to jobs in the private sector after they've been working in the competition authority. And so there's a turnover. In addition, we see so many changes in society, including technological developments. So remain robust and clever as an enforcer means constant effort. So that is, of course, a main priority. However, we are also developing as an organization. And right now, we are in the process of reorganizing a little bit for two purposes. One, we changed the organization a little bit in order to make sure we have more cases coming in. We need more cases in the pipeline. We need to detect more cases and complete more cases. So we do some changes in the organization to get there. And the other thing we do is that we establish a separate unit for data and analysis that can serve the whole organization. And that is similar to other agencies. We want to make use of the new opportunities in artificial intelligence, go through data quicker and better, and be able to manage bigger data sets so that we can work better ex officio and do important analysis for the cases we have.
That makes a lot of sense. Did those changes start with you and your tenure at the organization?
The organization has been focused on evolving all the time, so I think it has worked quite well. And I think before I came into office, I think they can be proud that they managed to go after some of the biggest Norwegian companies. And we also achieved to raise the level of fines. So we have post penalties in line with the guidelines from the EU Commission. And that means quite high penalties, higher than other agencies in Norway. Those achievements are a result of work that started before I came in.
And can you talk to us about any particular accomplishment or initiative that the authority has worked on during your time as Director General?
This thing that I mentioned about the reorganizing for detecting cases, that's one. And another thing that I focused on right away is data and how we can work even better on data, we can get better data, and how we can be able to manage bigger data sets. But the organization was already very digital, so it was a good place to come to have such a focus.
How do you see that playing out? Like, what's your ultimate goal in putting those changes into place?
Well, that's quite simple. I want to see more cases. I want to see more cases completed and detected, first of all, of course. And what I see is that the organization is not ready to take on many big enforcement cases, because each case requires so many resources, because they are appealed and they go on for so many years, and especially abuse of dominance cases. So one of the things that I have also been focusing on is how we can start to complete more cases in alternative ways, conclude cases with settlements, remedies, commitments, whatever, so that we can have more cases brought in, but also conclude more cases in alternative So I don't think we will manage to increase the number of big enforcement cases that much because they will continue to require so many resources. But I think we can have a higher, we will be perceived to have a higher detection rate if we increase the quantity of cases that we do something about, that we have some sort of conclusion.
Yeah.
So that is a clear aim. And that also resonates very well with my background, because as a professor, I've been focusing on corporate liability and enforcement, and studied how this happens across countries and across criminal, non-criminal systems.
Very interesting. With your background and your time in the authority now, what is the most important trend that you see developing in competition law enforcement kind of in the near term?
The most obvious is, of course, related to artificial intelligence, because that will not only change the market, it will also make us more efficient. I'm convinced about that. But I also think that if we manage to increase the number of cases, we will see an increase in leniency applications. So I think there has been a challenge recently across the world. We know there has been a reduction in the number of real leniency applications. But if we succeed on other areas, I think we will manage to see an increase in leniency applications, because there's so much focus on that now. We see that it's not working the way it should. So I think that is, I hopefully, optimistically think that will happen. In addition, I think European agencies will improve with respect to abuse of dominance cases. It takes so long time, as I mentioned, and with new guidelines and also all the things that happen in tech, I think we will, again, I hope we will be able to manage those cases in a quicker way. You know, it should be easier than a cartel where you have many players, or at least 3-4 players, compared to an abuse of dominance case where you only have one. And but it is the opposite, even if the cartel cases are not easy.
Yeah. Why do you think that is?
I think that's it's very hard to find evidence and make sure to bring the case above the threshold for intervention, because it's very hard to prove something that happens totally inside of the organization and prove intention, and to the extent that we need to do that. And but I don't really know. So that's one of the things I want to spend more time studying.
Well, thank you so much for giving our listeners a chance to hear, directly from you what your thoughts are on competition policy and what's going on with the Norwegian Authority. And we always leave our listeners with something about our guests, right? So do you have any interesting hobbies outside of competition law that you could share?
Well, I spend a lot of time on the Norwegian form of yoga, which means to go for long hikes in the mountains, on foot or skiing or alone or together with some sort of company. But my job takes so much time, so I actually prefer to call it jobby instead of I'm asking for hobby.
I think we're all probably familiar with a jobby. Thank you so much.
We hope you enjoyed this special edition of Our Curious Amalgam. For more details about the competition agencies featured in this episode, we'll post links to the agency websites on the episode webpage. Thank you for listening, and join us for next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org. Antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.